everybody to this landmark Chambers seminar on service charges in the Supreme Court. I am going to be speaking first. My name is David Holland, KC, and I'm too old and decrepit to need any form of introduction. I will be joined today by my colleagues Camilla Lamont and Simon Allison. Camilla, again, probably doesn't need introduction to any of you, but she's a senior, called in 1995. She's a senior junior who's ranked in Tier 1 real estate litigation by Chambers UK and has twice been named Real Estate Junior of the Year at the Chambers UK Bar Awards in 2017 and 2021. She's a well-established reputation in the field as a user-friendly advisor and advocate who combines intellectual acumen with an understanding of the commercial realities facing clients. She undertakes work in all areas of property litigation, including real property, landlord, tenant. She's extensive experience in service charge litigation, both commercial and residential, and is the author of the chapter in Hill and Redmond on the statutory regulation of residential service charges and management. Simon Allison was called in 2005. He's a specialist property practitioner. He's described in the Legal 500 as, quote, an excellent advocate, unquote, and as, quote, one of the best barristers in the property field, unquote. Simon relishes all form of advocacy and has appeared in all levels of court and tribunal, including recently appearing twice in the Supreme Court. He's widely recognised as a specialist in building safety, leasehold management, forfeiture and service charge cases, and has appeared in a number of the leading cases in this area. However, he's keen for me to emphasise that he also enjoys taking instructions in other areas. I don't think that means crime or personal injury, that's other areas of property law. He appeared for the successful landlord in Aviva, along with Brooklyn, also in Chambers, from the first tier tribunal through the upper tribunal and Court of Appeal, all the way to the Supreme Court, and he's going to talk about that case in a little bit. Right, well, it's for me to start, and I am going to talk about the case of Sara and Hossein. We know, because no less a person than Lord Neuberger has told us, that there are no special rules of construction that apply to the service charge clauses and leases. In Arnold and Britain, Lord Neuberger said, this reference was made in argument to service charge clauses being construed restrictively. I'm unconvinced by the notion that service charge clauses are to be subject to any special rule of interpretation, even if, which it's unnecessary to decide, a landlord may have simpler remedies than a tenant to enforce service charge provisions. That is not relevant to the issue of how one interprets the contractual machinery for assessing the tenant's contribution. The origin of the adverb was a judgment by Lord Justice Ricks in McHale versus Erica Duggan. What he was saying quite correctly was that the court should not bring within the general words of the service charge clause anything which does not clearly belong there. However, that does not help to resolve the sort of issue of interpretation raised in this case. The very recent case of Sara and Hossein versus Black's Outdoor Retail, to my mind, could be said to evidence a quiet but distinct shift away from the more literalist principles of construction adumbrated in cases like Arnold and Britain. Indeed, it may herald a swing of the pendulum back towards an approach that places greater weight on commercial common sense or so-called commercial reality. Now, one starts where one normally does in matters of contractual construction, with Lord Hoffman's famous 5 points set out in the case of ICS and West Bromwich Building Society. That case involved the construction of a particular clause in a claim form, which had to be completed by an individual investor who wished to make a claim for compensation from the investor's compensation scheme in respect of losses incurred by that investor as a result of the negligence of an independent financial advisor, which financial advisor had then become insolvent. The form provided that the investor seeking compensation should assign to the ICS all rights arising out of the transaction against the independent financial advisor. However, there was an exception to that assignment for, quote, any claim, open brackets, whether sounding in rescission for undue influence or otherwise, close brackets, that you have or may have against the West Bromwich Building Society, in which you claim an abatement of sums which you would otherwise have to repay to the society. As Lord Hoffman noted, according to ordinary rules of syntax, any claim is the antecedent of that you have, and the words or otherwise in the adjectival parenthesis mean that it does not limit the breadth of any claim. It followed from this that claims of any description were excluded as long as they amounted to claims for an abatement of what was owing to the society. There were various ways in which the amounts owing might be abated, but one would be on account of set-off against the society's liability for damages. Thus, the syntax of the words following any claim pointed to a wide meaning of abatement, which included the effect of cross claims. The judge of first instance had, however, stated that this literal construction could not be correct, as it led to a, quote, ridiculous commercial result, which the parties to the claim forms were quite unlikely to have intended, unquote, and that it was clear that, quote, the drafting of the second paragraph of section 3b was mistaken, unquote. He therefore concluded that the meaning intended by the parties was that the investor should retain, quote, any claim for an abatement of his debt which arose out of a claim for rescission, whether for undue influence or otherwise, unquote. The Court of Appeal overturned his decision and stated that the judge's interpretation was not an available meaning of the words. The words, quote, any claim, open brackets, whether sounding in rescission for undue influence or otherwise, close quote, could not mean, quote, any claim sounding in rescission, open brackets, whether for undue influence or otherwise, close quotes. And that was that. The Court of Appeal was unimpressed by the alleged commercial nonsense of their preferred construction. The House of Lords, by a majority, restored the judge's conclusion. It was in this context that Lord Hoffmann set out his famous 5 principles of contractual interpretation. The fifth of these was as follows. The rule that words should be given their natural and ordinary meaning reflects the common sense proposition that we do not easily accept that people have made linguistic mistakes, particularly in formal documents. On the other hand, if one would nevertheless conclude from the background that something must have gone wrong with the language, the law does not require judges to attribute to the parties an intention which they plainly could not have had. Lord Diplock made this point more vigorously when he said in the Antaeus case, quote, if detailed semantic and syntactical analysis of words in a commercial contract is going to lead to a conclusion that flouts business common sense, it must be made to yield to business common sense, end of quote. It is, in my view, worth bearing in mind the quoted words of Lord Diplock when one comes to consider the later Supreme Court cases. In answer to the argument the adopted meaning was, quote, doing violence, unquote, to the natural meaning of the words, Lord Hoffmann said this, many people, including politicians, celebrities, and Mrs. Malaprop, mangle meanings and syntax, but nevertheless communicate tolerably clearly what they are using the words to mean. If anyone is doing violence to natural meanings, it is they rather than their listeners. This approach of giving, if not primacy, then key importance to commercial common sense reached its apogee in Lord Hoffmann's last case, which was Chartbrook and Persimmon. That case involved the construction of a payment or overage provision in the sale of some development. The purchaser-developer was to construct and sell flats, and then make payment to the vendor of what was called the additional residential payment, or ARP. It was defined as follows. 23.4% of the price achieved for each residential unit in excess of the minimum guaranteed residential unit value, less the costs and incentives. This contained 3 more defined concepts. Residential unit meant a flat. The minimum guaranteed residential unit value, MGRUV, meant the total residential land value divided by the number of flats, and the costs and incentives, C&I, meant the additional expense which the developer might have to incur to induce someone to buy the flat. The first instance judge and the majority of the Court of Appeal had agreed with the vendor that the definition was perfectly simple. One took the price achieved for each flat, deducted the MGRUV and the C&I, and calculated 23.4% of the result. That gave one a figure for an individual flat, which, together with the figures for similar calculations on all the other flats, made up the ARP, or balancing payments. That and the total land value was the price. On the agreed figures, that interpretation produced a figure for ARP of just over £4.4 million. The first instance judge, Mr. Justice Briggs, who we'll come back to, said this, ARP means 23.4% of something. To the question, 23.4% of what? The clear answer is the excess of the price achieved for each residential unit over the MGRUV, less the costs and incentives. The House of Lords, however, disagreed. It agreed with the construction placed on the clause by the developer. One deducted C&I from the realised price of any flat to arrive at the net price achieved by the developer. One then calculated 23.4% of that price, and the ARP was the excess of that figure over MGRUV. ARP had to mean the amount by which 23.4% of the achieved price exceeded the MGRUV. On this calculation, the overall ARP was only £897,000. Lord Hoffman said that to interpret the definition of ARP in accordance with the ordinary rules of syntax made no commercial sense. He said this: it clearly requires a strong case to persuade the court that something must have gone wrong with the language, and the judge in the majority of the court of appeal did not think that case had been made out. On the other hand, Lawrence Collins LJ thought that it had. I'm afraid not unusual that an interpretation which does not strike one personally as sufficiently irrational to justify a conclusion that there's been a linguistic mistake would seem commercially absurd to another. The subtleties of language are such that no judicial guidelines or statements of principle can prevent it from sometimes happening. It is fortunately rare because most draftsmen of formal documents think about what they're saying and use language with care. But this appears to be an exceptional case in which the drafting was careless and no one noticed. Thus, in that case, the House of Lords held that a definition of a term in a contract which aligned with the ordinary rules of syntax, but which flouted business common sense, should be rejected, and the construction which better fitted business common sense should be adopted. It's also worth noting the following passage in Lord Hoffman's speech. I do not think that it's necessary to undertake the exercise of comparing this language with that of the definition in order to see how much use of reading is involved. When the language used in an instrument gives rise to difficulties of construction, the process of interpretation does not require one to formulate some alternative form of words which approximates as closely as possible to that of parties. The fact that the court might have to express that meaning in language quite different from that used by the parties is no reason for not giving effect to what they appear to have meant. Lord Hoffman then retired. The next case with which I want to deal is Rainey, Sky and Cookman Bank in 2011. That case involved the correct construction of shipbuilders' refund guarantees given by a bank pursuant to 6 shipbuilding contracts. I will not set out the terms of the relevant contracts as they are comparatively long and complicated. However, in the course of his judgment, Lord Clark expressed approval of this passage in the judgment of Sir Simon Tuckey in the Court of Appeal. If the language of the bond leads clearly to a conclusion that one or other of the constructions contended for is the correct one, the court must give effect to it, however surprising or unreasonable the result might be. But if there are 2 possible constructions, the court is entitled to reject the one which is unreasonable, and in commercial context, the one which flouts business common sense. Lord Clark's comments in this case must be put in context. In the Court of Appeal, another of the judges, Lord Justice Patton, had stated that unless the most natural meaning of the words produces a result which is so extreme as to suggest that it's unintended, the court has no alternative but to give effect to its terms. Lord Clark expressly disagreed with that statement. Now, whilst he did say, where the parties have used unambiguous language, the court must apply it, he then added this: it's not in my judgment necessary to conclude that unless the most natural meaning of the words produces a result so extreme as to suggest that it was unintended, the court must give effect to that meaning. The language used by the parties will often have more than one potential meaning. I would accept the submission made on behalf of the appellants that the exercise of construction is essentially one unitary exercise in which the court must consider the language used and ascertain what a reasonable person, that is, a person who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract, would have understood the parties to. Thus, Lord Clark was intending to emphasise that in order to depart from a particular meaning of words set out in the contract, one did not have to hold that a natural or ordinary meaning produced an extreme result. There simply had to be some doubt or ambiguity. These passages were, however, latched onto by Lord Newburger in the famous case of Arnold of Britain. That case, of course, involved the construction of service charge provisions in 99-year leases of holiday chalets in Wales. The relevant provision was this: the tenant was to pay to the lessors without any deduction, in addition to the said rent, a proportionate part of the expenses and outgoings incurred by the lessors in the repair, maintenance, renewal, and the provision of services hereafter, set out in the yearly sum of £90 and VAT for the first 3 years of the term, hereby granted, increasing thereafter by £10 per hundred for every subsequent 3-year period or part thereof. The landlord contended that these service charge provisions had the effect of providing for a fixed annual charge of £90 for the first 3 years, increasing for each subsequent 3-year period by 10% on a compound basis. This would have had the effect that if one assumed a lease granted in 1980, the service charge would be over £2,500 in 2015, and over £55,000 a year by 2072. Now, Lord Neuberger admitted that this outcome was, quote, unattractive, indeed alarming. The tenants sought to avoid this primarily by contending that the respondent landlord's construction resulted in such an increasingly absurdly high annual service charge in the later years of the 25 leases that it could not be right. They argued that, properly read, each service charge clause in the 25-year leases requires the lease to pay a fair proportion of the lessor's cost of providing the services, subject to a maximum, which is £90 in the first year of the term, first 3 years, and increases by 10% on a compound basis in every other period. In other words, the appellant tenants argued that, in effect, the words up to should be read into the clause set out above, between the words the provision of services hereafter set out and the words the yearly sum of £90. Now, as we know, the Supreme Court rejected the tenants' arguments and held that the landlord was correct, despite the alarming result. In his speech, Lord Neuberger emphasised a number of points. These, of course, included the following at paragraphs 17 to 20 of the judgment. First, reliance placed in some cases on commercial common sense and surrounding circumstances, e.g. Chartbrook, should not be invoked to undervalue the importance of the language of the provision which is to be construed. Secondly, the process of construction, however, does not justify the court embarking on an exercise of searching for, let alone constructing, drafting infelicities in order to facilitate a departure from the natural meaning. The third point I should mention, is that commercial common sense is not to be invoked retrospectively. The mere fact that a contractual arrangement, if interpreted according to its natural language, has worked out badly or even disastrously for one of the parties is not a reason for departing from the natural language. Commercial common sense is only relevant to the extent of how matters would or could have been perceived by the parties or by reasonable people in the position of the parties as at the date of the contract was made. Fourthly, a court should be very slow to reject the natural meaning of a provision as correct, simply because it appears to be a very imprudent term for one of the parties to have agreed, even ignoring the benefit of wisdom and hindsight. Many people, myself included, saw this emphasis on literalism and the primacy of the words of the contract as a distinct departure from particularly Lord Hoffman's fifth principle in ICS, which of course included the reference to Lord Diplock's judgment in the Antaios case. And if I go back to that, remember Lord Diplock had said, quote, if detailed semantic and syntactic analysis of words in a commercial contract is going to lead to a conclusion that flouts business common sense, it must be made to yield to business common sense. I see those words as directly contrary in many respects to the four principles which I've just described, set out by Lord Neuberger in Ireland and Britain. So I saw, and many other people did, that there was a distinct difference of emphasis, to say the least, between what was said in Ireland and Britain and what had been said some years earlier in ICS. Now, this was not, of course, what the Supreme Court thought, or at any rate said. In the subsequent case of Wood and Capita, a case involving the construction of a provision in the contract for the sale of shares in the company, one of the parties sought to argue that, quote, the decision of this court in Ireland and Britain has rolled back from the guidance on contractual interpretation which this court gave in Rainy Sky and Cookman Bank. This point, end quote. This point was given short shrift by Lord Reid, who asserted that Arnold had not altered the guidance given in Rainy Sky. He said, textualism and contextualism are not conflicting paradigms in a battle for elusive occupation on the field of contractual interpretation. Rather, the lawyer and the judge, when interpreting any contract, can use them as tools to ascertain the objective meaning of the language which the parties have chosen to express. Lord Neuberger then retired. And we then come to the case of Sara and Hossein versus Black's Outdoor Retail. That case involved the construction of one clause in service charge provisions in the lease of retail premises in Liverpool. Under clause 2.3 of the lease, the tenant was required to pay rent and, quote, the service charge calculated and payable at the times in accordance with Schedule 6. Clause 3.1a contained a no set-off provision under which the tenant covenanted to pay the yearly rent reserved by the lease at the times and in the manner required under clause 2.3, and not to exercise or seek to exercise any right or claim to withhold rent, or any right or claim to legal or equitable set-off or counterclaim, save as required by law. That was accepted by both parties that this provision applied to all sums due under the lease, including the service charges. The service charge provisions are, as stated, were in Schedule 6. Under paragraph 4, the tenant was required to make quarterly payments on account of service charge in accordance with written estimates from the landlord. Under paragraph 1, at the end of each service charge year, the landlord was required to calculate both the total reasonable and proper cost to it of providing both the services and expenses specified in part 2, excluding costs and expenses by insurers. Under paragraph 2, the tenant was required to pay both a fair and reasonable proportion of that total cost. Paragraph 6 provided that this proportion should be, quote, the proportion which the net internal area of the demised premises bears to the net internal area of the aggregate of all areas of the building, unquote, let or intended to let. It further provided that a dispute over such proportion should be determined by expert determination. The definitions in clause 1.1 provided that this was to be by an independent valuer, that both parties were to be given an opportunity to make representations. Now, the important clause is the one up on screen. Now, it was paragraph 3 to Schedule 6, which provided the landlord shall on each occasion furnish to the tenant, as soon as practicable, after such total cost and the sum payable by the tenant shall have been ascertained, a certificate as to the amount of the total cost and the sum payable by the tenant, and in the absence of manifest or mathematical error or fraud, such certificate shall be conclusive. The dispute between the parties arose when the tenant did not pay the service charge demanded by the landlord for the service charge years 2017-18 and 2018-19. For the previous year, 2016-17, the landlord had demanded around £55,000, which the tenants had paid. However, for the 2017-18 year, the landlord certified that over £400,000 was payable in circumstances where it knew that the tenant would be terminating the lease in May 2019. The tenant, perhaps unsurprisingly, smelt a rat and objected, claiming that this charge was excessive and included unnecessary items and expenses which fell outside the terms of the lease. For the 7 months of the 2018-19 year, up to the expiry of the lease in May 2019, the landlord certified that around £62,000 was paid. The dispute about the meaning and effect of the certification provision reached the Supreme Court. The certification provision is the provision that you see on the screens now. The Master and the High Court judge had agreed with the tenant and held that the landlord's certificate was conclusive as to the amount of costs incurred, absent manifest or mathematical error or fraud, but was not conclusive as to the question of whether those costs, as a matter of principle, fell within the scope of the service charge payable to the tenant under the lease. The Court of Appeal, however, disagreed with the landlord. It held that the natural meaning of the crucial words in the certification provision, that the certificate is to be conclusive as to 1, the amount of the total costs, and 2, the sum payable by the tenant, was that the certificate was conclusive as to both those elements and not merely the first of them. They held that treating the categorization of the relevant services and expenses as not being conclusively determined by the certificate would require express words to that effect or necessary implication. There were neither such express words nor grounds for necessary implications to that effect in the lease. The Supreme Court, by a majority of 4-1, agreed with the landlords. They first of all agreed with the tenants. The Supreme Court agreed with the landlords that the words a mathematical error and fraud were clear and narrow in scope. Further, a manifest error is one that is obvious and or easily demonstrable without extensive investigation. Manifest errors, they said, were oversights and blunders so obvious and obviously capable of affecting the determination as to admit of no difference of opinion. There was thus no fraud, mathematical error, or manifest error here. Now, both parties maintained their positions before the Supreme Court. The court summarised the landlord's position as, quote, pay now, argue never, unquote, whilst that of the tenant was, quote, argue now, pay later, unquote. The court found neither of these positions to be satisfactory. It set out the relevant principles of contractual construction summarised in those words. 1, the contract must be interpreted objectively by asking what a reasonable person with all the background knowledge which would reasonably have been available to the parties when they entered into the contract would have understood the language of the contract. 2, the court must consider the contract as a whole and, depending on the nature, formality, and quality of its drafting, give more or less weight to elements of the wider context in reaching its view as to its objective meaning. 3, interpretation is a unitary exercise which involves an iterative process by which each suggested interpretation is checked against the provisions of the contract and its implications and consequences are investigated. Now, the majority accepted that the natural and ordinary meaning of the certification provision supported the landlord's case. On the other hand, they accepted the force in the tenant's point that in interpreting a contract, one starts with the presumption that neither party intends to abandon any remedies which arise by operation of law, and that clear words are necessary to do so. They didn't like the fact that the landlord's case meant that the tenant could never challenge any of the calculations, save in very narrowly limited circumstances. The majority said this: adopting an iterative approach, neither party's interpretation is satisfactory. The landlord's case fits well with the wording of the certification provision, but not the wider contractual context. It suits the landlord's commercial purposes, but produces surprising and uncommercial consequences. Subject only to the permitted defences, it is a pay now, argue never regime. Conversely, the tenant's case is supported by the internal context of the contract, but not the certification of the sum payable by the tenant. It avoids the uncommercial consequences of the landlord's interpretation, but undermines the landlord's need for reimbursement of costs and expenses incurred with minimal delay and dispute. It is an argue now, pay later regime. Now, the majority adopted a middle way, which was an alternative interpretation, which they said avoided the difficulties in either party's case. It was that A, the landlord's certificate is indeed to be conclusive as to what is required to be paid under the Schedule 6 regime, subject only to the permitted defences. No set-off was allowed, so the landlord got its cash flow up front. B, however, payment of the certified sum did not preclude the tenant from thereafter disputing liability for that payment. This was not precluded by the no set-off provision, the purpose of which was to prevent the tenant from holding up payment by the assertion of disputed claims. It barred any counterclaim that took effect as a set-off, but did not extinguish the right to bring a counterclaim. Thus, the certification provision was to be interpreted as being conclusive as to the service charge sum payable by the tenant, but not as to the underlying liability for the service charge. The tenant was entitled to bring a claim seeking repayment of a cost which he contended it had been improperly charged. It was a form of pay now, argue later provision. The majority concluded, adopting an iterative approach, this interpretation is consistent with the contractual wording. It enables all the provisions of the leases to work together satisfactorily, and it avoids surprising implications and uncommercial consequences. Thus, the court adopted a meaning of the certification provision which was contrary to its natural and ordinary meaning, but which best accorded with commercial common sense. To my mind, this signals a move away from the strictures set out in Arnold, Britain, and a move back towards the primacy of commercial common sense. This appears to be the view of Lord Briggs, him again, who dissented. He cited from Arnold and Britain and said this: it might be said that a pay now, argue later regime is the plainly commercial solution which reconciles the parties' opposing interests in relation to the proper determination and prompt payment of service charges. It is precisely the commercial alternative construction to which a court would be happy to be driven, where the plain meaning of the words appears uncommercial, and where the only competing construction proffered is also uncommercial, albeit for different reasons. But it is well settled that the uncommerciality of the prima facie meaning of contractual words only yields to a more commercial alternative if there is some basis in the language of the contract as a peg upon which that alternative can properly be hung. I have been unable to find any peg within the language of the lease upon which to hang the construction that shall be conclusive at the end of paragraph 3 means only conclusive as to the requirement to make a balancing payment on the next quarter day following the furnishing of the certificate, but leaving ultimate liability up for grabs disputed. Thus, Lord Briggs' view was that the majority interpretation was an illegitimate one for which there was no warrant in the words of the lease. He would have adopted what might be described as an orthodox Arnold and Britain construction and agreed with Court of Appeal. Now, personally, I can see force in Lord Briggs' point. However, I agree with the majority and welcome a move away from what Lord Reid would describe as textualism. I'll now hand over to, I think it's Simon.
Thank you, David. I'm going to be speaking to you about Aviva and Williams, which is a case that I was fortunate enough to be involved with from the very outset when the application to the first tier tribunal was brought and see it through 3 appeals. And the issues in Aviva were summarised by the Supreme Court into 2 sentences. Firstly, to what extent is a term in a residential lease, which allows the landlord to revise the tenant's share of the service charge is invalidated by section 27A6 of the Landlord and Tenant Act 1985. And secondly, if the effect is that any discretion to reapportion service charge is transferred from the landlord to the first tier tribunal, does section 27A6 enable the tenant as well as the landlord to invoke the tribunal's jurisdiction? Certainly the latter of those may strike those of you less familiar with this case as a somewhat surprising question to the Supreme Court to end up resolving. So I'm going to set out a little bit of background first. I'm conscious some of you may not be familiar with the statutory overlay that applies to residential service charges payable under long leases, but many of you will be, so I'm not going to dwell here for long. But just as a sort of start of the 10, sections 18 to 30 of the 85 Act consist of a wide variety of provisions. Don't be fooled, there's sections 20 A, B, C, and D, and so on and so forth. A wide variety of provisions that effectively modify the rights and obligations between landlord and tenant with respect to the payability of service charges. Broadly, they make life more difficult for landlords and provide a considerable degree of protection to tenants, and indeed that has been Parliament's purpose throughout. There's a long statutory history to some of the provisions that I won't bore you with, but some predate the 85 Act and others have been added over time. And the way those rights interact with our roles as litigators is chiefly through section 27A, which you can see on the screen. Section 27A1 provides an application may be made to the appropriate tribunal for a determination whether a service charge is payable, and if it is, as to the person by whom it's payable, the person to whom it's payable, the amount which is payable, the date and the manner. So those are the statutory questions. And don't forget, of course, the first tier tribunal, and that's in England, the LVT in Wales still, is a creature of statute. So it can't go beyond determining those points that are set out in statute. It has no general declaratory jurisdiction to determine points of dispute between the parties. There is an equivalent, section 27A3, I haven't put it on the slide, but that provides that you can ask the tribunal to determine all of those points prospectively before you incur a cost. But nonetheless, it is a relatively wide jurisdiction, but you do have to be answering that question. And what you then have after section 27A1, at the end, section 27A6 is this provision. An agreement by the tenant of a dwelling other than a post-dispute arbitration agreement is void insofar as it purports to provide for determination in a particular manner or on particular evidence of any question which may be the subject of an application under subsection 1 or 3. And it's this provision that's the focus of the appeal in Aviva. What do these words mean? It's helpful to try and commit them to memory because that's what we need to be thinking about as we look at the decision. Now, it's probably clear from the off, this is an anti-avoidance provision at the very least. It's rendering void an agreement. So, for example, a lease, a part of a lease that purports to in some way oust the tribunal's jurisdiction. And really the question is, well, how far does that go? Now, life was fairly settled up to 2013 in the context of the issues in this appeal, at least. If we think about how the LVT, for it was of course still the LVT up to about 2013 in both England and Wales, how the LVT would approach a challenge to, for example, apportionment of service charges between different service charge payers was pretty settled. We thought we knew how this all worked. If the proportion of service charges payable by the tenant was fixed by the lease, 5%, the LVT had no jurisdiction to do anything. That's because section 27A4 says tribunal can't do anything if something's been agreed. If the proportion payable was variable in some way, and then the LVT's function was to review the landlord's apportionment. So if the requirement was to pay a fair and reasonable proportion, the LVT would ask whether the landlord had adopted a fair and reasonable apportionment out of no doubt a wide range of other fair and reasonable ways of doing it. And it would really be a pretty rare case where an apportionment challenge would succeed before the LVT. The classic example was where the landlord was recovering more than 100%. They'd start delving into it more deeply, but even then, there's no reason in theory, certainly with fixed proportions, where that's not possible. But of course, the starting point in most apportionment disputes is to say, well, the landlord probably hasn't got much skin in the game. So the landlord can be left to find a way to recover its 100% in a relatively dispassionate way. Now, on occasion, and those of you who worked in this area at the time will recall this, the LVT would step outside of that box and start assessing whether the service charges as apportioned were generically reasonable, based, one assumes, on a simplistic view that their only role was to work out if the service charges were reasonable and then encompass the apportionment questions within that general reasonableness question. Many of you will be familiar with Section 19 of the 1985 Act, because that's where we get our reasonableness concept in residential service charges from. Section 19(1) says relevant costs shall be taken into account in determining the amount of a service charge payable for a period, A, only to the extent that they are reasonably incurred, and B, where they are incurred on the provision of services or the carrying out of works, only if the services or works are of a reasonable standard, and the amount payable should be limited accordingly. So the focus in Section 19 is on the costs that have been incurred, not on how you divide those costs up. So, you know, where that happened, where the LVT tried to consider the reasonableness of apportionment generally, i.e. tried to apply the Section 19 test, the Lands Tribunal, as it then was, would put things right. And you can see that in the Shilling and Canary Riverside case. I've put the citation on the screen. There, the lease provided for fixed percentages, except the landlord was entitled to vary those percentages in two specific scenarios that hadn't arisen on the facts, i.e. where there'd been a replanning of the layout of the estate, or whether services in the building were to be shared with other premises. And the applicants challenged their allocation of various service charge items on the basis they had to be reasonable under Section 19 of the Act. And His Honour Judge Rich concluded, so paragraph 19, that the applicant's approach was not what Section 19 provided for. He said, costs are to be taken into account only to the extent they're reasonably incurred, but if reasonably incurred, they fall to be apportioned in accordance with the terms of the lease, except if excluded by failure to consult or otherwise. So in other words, Section 19 has nothing to do with apportionment of service charges. The tribunal was there purely to exercise a review function. Has the landlord apportioned in accordance with the contractual mechanism? So there we were up to 2013, and then a little seed was sown by Mr. Justice Morgan in the case of Shulham B. And this is actually the first time there's a reported decision where Section 27A(6) had been considered, notwithstanding it had been in force for some time by that point. And even then, in Shulham B, in fact, the parties hadn't actually thought of the point. This is a point that Paul Morgan thought of and put in his judgment, but no one had actually argued it. And you can see it's the reference on the slide. The fourth point, the facts of the case don't matter. The fourth point is that the amount of the proportion in the case of the difference is to be settled by the surveyor of the lessor, whose decision is stated to be final. It may be that this reference to the finality of the surveyor's decision is no longer contractually effective in view of Section 27A(6). I should say I did not hear specific arguments on that point. But his point, with respect, was a good one. If what the surveyor was to determine as to the proper proportions was to be final, in the sense of being binding on the parties, that would oust the jurisdiction of the tribunal to answer that Section 27A payability question. Accordingly, it would be void. That's the logical way of reading Section 27A(6). That conclusion is right, and indeed survives the Supreme Court's analysis in Aviva, as we'll see. But that planted a seed, that little paragraph planted a seed in various lawyers' minds and led some fairly interesting further arguments, and ultimately led us to the Supreme Court at the tail end of 2022. And that's where we come to a case, after the seed had been sown, it came to be argued in Windermere and Wild, this in 2014 before the Deputy President. Now, in Windermere, the lease contained a single method of apportionment. It required the tenant to pay a fair proportion of the service charges, which was to be calculated by a determination carried out by the landlord surveyor, which was said to be final and binding on the lessees. And there's no doubt that the reference in that lease to the determination being final and binding would fall foul of section 27A6, because it purports to prevent the tribunal from reviewing the surveyor's determination as to whether or not it results in a fair proportion being payable. But in Windermere, the Deputy President went a bit further than that. He said the entire role of the landlord surveyor in deciding the fair and reasonable proportion offended section 27A6 because it had the effect of providing for the manner in which an issue capable of determination under section 27A1 was to be determined. Namely, so the manner was a binding decision of the appellant surveyor. He said, I can't accept Mr. Gilchrist's submission that the apportionment of service charges is not a question which arises under subsection 1, or that subsection 6 is directed only at provisions which purport to make a determination of the relevant expenditure by the landlord surveyor or accountant determinative. So as a consequence, he held it was for the tribunal to determine what amounted to a fair proportion. And that's because the contractual mechanism for identifying that fair proportion had been rendered void by section 27A6, i.e. the tribunal was in effect filling a vacuum created by the deletion of the offending words, and the tribunal was to become the decision maker in place of the landlord surveyor. So the tribunal was substituting its own view of what the correct proportions are for that of the landlord. It wasn't there reviewing whether the surveyor had come up with a fair and reasonable proportion. It was saying a fair and reasonable proportion is X, that may or may not be the same as the landlord surveyor. And on a practical level, of course, that meant no matter how carefully a landlord set its apportionment percentages, it was at risk that the tribunal would come to a different decision in the event that anyone challenged the proportions. But with no freestanding declaratory jurisdiction, there wasn't an easy way to know the answer in advance. You could contrive a section 27A3 prospective determination application, but that's an expensive and a lengthy process and doesn't help you when you're issuing your service charge demands every 6 months for on-account service charges, for example. And in Aviva, we were arguing that it was from this point, from this decision in Windermere in 2014, that the law had gone on an incorrect tangent. If you look through Windermere, you'll see at paragraph 42, the Deputy President appears to conflate the fact that the issue might concern apportionment with the question that the tribunal has jurisdiction to determine. Those questions, you'll recall, we looked at the beginning. And he found that because the lease had provided that the answer to the question of what proportion of the expenses should be paid by the applicant should be determined by the landlord, whether or not it was final and binding, that provision was void. And so we found ourselves ultimately in this case having to explain why that was the wrong approach. Now there were then further cases that followed on from Windermere and Wild. In fact, one of them, Gator, followed on so closely. It was only, I think, about 6 or 7 weeks later, and the Deputy President heard it again and agreed with himself and upheld his decision in Windermere and applied it again in Gator in pretty similar circumstances. Gator was a case where the tenant was due to pay a due and fair proportion to be determined by the landlord or its surveyor, in each case acting reasonably, and then it also contained a determination, a provision that the determination would be final and binding. And counsel in that case sought to persuade the judge again that it was only the final and binding part that was caught by section 27A6, but they failed. As the determination being by the landlord or its surveyor was purporting, he found, to provide for a determination in a particular manner. There were a number of other cases as well. I'm not going to run through them all, but most material for present purposes is that both Windermere and Gator were then affirmed in a case called Sheffield and Oliver in 2017 by the Court of Appeal, where they approved Windermere and Gator, but without, so far as we can see in the case report at least, being referred to the legislative history or any consideration of the degree to which those decisions represent any kind of departure from the previous review jurisdiction of the tribunal. As I understand it in Sheffield and Oliver, it really was a peripheral point and one that came up fairly last minute on both sides. Nonetheless, Sheffield and Oliver provided all of us practitioners with a binding Court of Appeal authority to the effect that section 27A6 was going to oust any real involvement of the landlord or the landlord surveyor in setting apportionment. So that was the backdrop to Aviva and Williams, and it's to that case that we turn now. This is a picture of the Vista block. It's a residential block in Southsea. There's a commercial unit on the ground floor. I think it sells merchandise for a local football club. There's 69 flats above, and it's part of a development with 3 buildings in total, mostly residential. There's a few more commercial units, and they have shared above and below ground parking. You can see that on the left-hand side of the picture, and some communal gardens above the car parks. 21st of November 2018, a group of leaseholders brought a challenge to the 28 service charges. It was pretty wide-ranging, as these challenges often are. The facts were unimportant, but it suffices to note that one of the many issues that fell for determination by the tribunal was the lawfulness of demands for the payment of service charges sent to the leaseholders. And what they said was that invalid apportionment percentages had been used. Here's a little excerpt from the lease, and you're looking at those bottom 3 bullet points. Your share of the whatever costs is X% or such part as the landlord may otherwise reasonably determine. And the challenge arose from the fact that Aviva had been, as indeed its predecessor in title, had been using a different set of percentages for the 3 categories of cost than those initial fixed percentages specified. There's a variety of reasons for that. One of the 3 blocks on the estate, for instance, was now in different ownership, and the initial percentages had assumed otherwise. Circumstances change, and that's why we have these sorts of provisions very commonly found in long residential leases. And what the leaseholders argued was that the provision in the lease deed for the landlord to apply a different alternative reasonable proportion was rendered void by section 27A6 and thus didn't apply. So they argued the landlord could only charge those fixed percentages, the initial fixed percentages in the lease, and for anything else they'd need written agreement from the leaseholders or an order from the tribunal. As was noted in the Supreme Court in their judgment, each of the 3 courts before the Supreme Court, when they were asked to determine this challenge, they each came up with a different answer. It's worth remembering at this point that the FTT and the Upper Tribunal were bound by Windermere and Oliver, the Court of Appeal was bound by Oliver, and Windermere and Oliver were cases where the proportions were not fixed at all. They were just fair and reasonable proportions, whereas here we have this initial fixed percentage. Now, in the FTT, the relevant parts of the decision are on the screen. I wouldn't normally quote extensively from the FTT's decision when it's got as far as it has, but spoiler alert, the Supreme Court decided that ultimately the conclusion that the FTT came to was the right one. I suspect they wouldn't wholly endorse the reasoning that you see on the screen, but they did come to the right answer. More on that in a minute. But very much in brief, in the FTT, I was arguing, well, you are bound by Windermere and Gator. That means that you have to make a decision, but I would like you to find that the apportionment percentages the landlord has used are the reasonable proportions that you would use, which was the only way to really deal with the Windermere decision. That isn't reflected in what the tribunal actually decided, which is what you see on the screen. If you haven't got to the end of that passage in reading it, you really don't need to. But the point is, what they said is, we don't think Windermere and Gator stops us making a decision, and we've considered whether the current apportionments are reasonable, and we find that they are. I'm just going to pause there for a minute. They had to find they were reasonable, not because of the section 19 question, but because you'll recall, if we go back to here, such part as the landlord may otherwise reasonably determine, so that lease itself is requiring, it's requiring that the alternative percentage has been reasonably determined, and that's what they're saying there. So they reject the leaseholder's challenge. Off we go to the Upper Tribunal, get permission to appeal, and they argued that Windermere was in their favour, and Judge Cook agreed with them. So determination on written representations, and I've just put a few excerpts from the judgment there. At 19, she said, this is a misunderstanding of the decision in Windermere and in Gator. That's a reference to my written arguments. Those decisions say that a clause purporting to provide for a determination of apportionment by the landlord or the landlord's agent is void. It is void whether or not it provides that the landlord's decision is final and binding or similar, whether or not the landlord agrees to submit to the jurisdiction of the tribunal. In the leases in question, this appeal, the words "or such person the landlord may otherwise reasonably determine" are void. They are deleted. They no longer appear in the lease. We're nearly in Monty Python territory at that point. And at 23, she says the deletion of the void wording in Windermere and Gate created a vacuum. There was still a determination to be made because the tenants had to pay a fair proportion of the service charge. In the absence of the agreed method of determination, it was for the FTT to decide what a fair proportion was, and it had to make its own decision. But in the present appeal, the remaining wording is different. The Vista lease set out a fixed percentage to which the landlord's discretionary apportionment is an alternative. There is no provision for a fair proportion or the like. Without the void wording, the lease obliges the tenant to pay a stated proportion of the service charge. There is nothing left to decide. So in other words, what the upper tribunal was saying, well, that wording is void. We get rid of that. There isn't then a vacuum for the tribunal to fill because the lease provides for an initial fixed percentage, and that's the end of it. All is well, you're stuck with that. We weren't happy with that, so off we went to the Court of Appeal. We got permission, and we appeared before Lord Justice Lewison. I do apologise for taking you through all of these decisions, but most of you will be litigators or people who instruct litigation lawyers, and ignoring the specifics of the case, when one thinks about litigation risks, the potential for judges to see things differently, this is a great example to bear in mind. 3 different tribunals, 3 different ways of analysing it, 3 different decisions. And by the Court of Appeal, leaseholders had representation. We were still unable to argue, of course, that Windermere was wrong because the Court of Appeal was bound by its decision in Oliver. I won't take you through all of the arguments we ran through there, partly because it really doesn't matter once you get to the Supreme Court decision. But Lord Justice Lewison finds this at 28. There's no doubt in my mind that the conclusions in these paragraphs followed logically from the premise. That's a reference to those paragraphs that we were looking at on this page. Follow logically from the premise that, as she held at 20, the effect of section 27A6 was that the words "or such part as the landlord may otherwise reasonably determine" were treated as having been excised from the lease. But that was not what Judge Gerald decided in Fairman, and Judge Cook did not say that he was wrong. The alternative approach is told the effect of section 27A6 was that the lease was to be read as if it had said "or such part as may otherwise reasonably determine," i.e. we delete the words "the landlord." And if that's the true effect of section 27A6, then there's a void which the FTT could fill, i.e. we then fill it with "or such part as the FTT may otherwise reasonably determine." So Judge Cook had painted herself into a corner. And so he forms the view, what we're concerned with here is not the form of drafting, but the substance of the impugned provision. It's a question of the effect and enforceability of agreed provisions, not their language or form. And he says, well, there's two aspects to that provision in the lease. The lessee is liable to pay a different percentage, A, to be identified by someone acting reasonably, and B, that someone is the landlord. So it's only the second part of that got deleted, so he found. And so it's now, of course, the tribunal that makes the decision. But it's worth thinking about the fairly radical effect that has, because the effect, if you insert the tribunal in place of the landlord, was to turn the unilateral right the landlord had to vary the proportions into a bilateral right, or more accurately, a multilateral right, because any leaseholder could apply to the tribunal to determine whether an alternative reasonable proportion should apply. And it was that curiosity, the fact that suddenly they're at the mercy of all their neighbours, all of whom could apply to the tribunal for determination, that led the leaseholders to apply to the Supreme Court for permission to appeal, which they got. Now, lawyers love to tell a tale of battle, but I'm not planning on giving that to you now. We're too short of time, and frankly, the very interesting, laborious to research arguments we had to run to deal with the principal case of the appellant didn't actually see much of light of day in the judgment. Fascinating points around the various tests of severance, but I'm not going to trouble you with that now. All you get to read in the Supreme Court's judgment, led by Lord Briggs, is Aviva's alternative case, which was to say, all of this is nonsense because Windermere is wrong, you should overturn Windermere. So our key arguments, you can see them in these bullet points. Firstly, if the effect of section 27A6 was to render all the words void for all purposes, then the tribunal was being denied jurisdiction. That wasn't the point. I mean, the whole heading of section 27A is jurisdiction of tribunal. and it's an anti-avoidance provision. The LVT had always been a review jurisdiction pre-Windermere. It's a matter of statutory construction. If Parliament intended the tribunal to impose its own decision to become some form of property manager, it would have said so, and in Windermere, the wrong question had been identified. And then there was this sort of more fundamental point, in fact, that if the tribunal was going to be the decision maker, as opposed to merely exercising a review function, why is apportionment in its own special box? If the landlord's involvement in setting the apportionment offends section 27A6 because it's a manner in which something is being determined, the same is going to be true when the landlord decides whether to repair a roof or replace it, and all manner of other discretionary decisions. And also the creation of the bilateral or multilateral right was massively expanding the scope of potential challenge. So it was this idea of a Pandora's box being opened. So then let's come to the judgment. Lord Briggs gives the leading judgment with which the other four justices agree. And the first thing they think about is, well, what are these questions the FTT is deciding under section 27A? And at 13, they note, well, questions arising under such an application are presumably questions of contractual entitlement and statutory regulation. To the extent they're regulated neither by statute contracts nor by statutes such as management decisions which the landlord's contractually entitled to make, they would not appear to fall within questions which may be the subject of an application under section 27A1 or 3. 15, in terms of this is whether the FTT should be making these sorts of discretionary decisions. They notice the jurisdiction of the FTT to decide whether a service charge demand is payable will extend to the contractual and or statutory legitimacy of these discretionary management decisions. Thus, where the service charge enables the landlord to recover its cost of performing its repairing obligations under the lease, replacement of a roof may give rise to questions whether replacement fell within the landlord's repairing obligation, whether if it was a repair the costs met the test in section 19. But it wouldn't be the FTT's task to make those decisions itself. So discretionary management decisions are not questions within section 27A1. If they had been, the jurisdiction of the FTT would be substantially enlarged from its existing review jurisdiction. This is the point we were looking at earlier. And it would confer an original jurisdiction on the FTT to determine all aspects of the service charge. That shouldn't be assumed, because this is quite clearly an anti-avoidance provision. And it would produce bizarre and surely unintended results, they say at paragraph 21. I note there's no basis for treating apportionment decisions differently from the other discretionary decisions affecting the amount of timing of service charges. All would be caught. And then they look at the Court of Appeals construction and say, well, you've got all those problems, plus also, and this is where the Pandora's box comes in, you're substituting the FTT for the landlord, thus you're creating a provision where any tenant can apply to the FTT any number of times for reallocation. Essentially, landlords would have no idea where they were because they can't make the decision, but there's no easy way of applying to the tribunal, and you'd have to reconsider it, the appropriate apportionment, every time you issued a demand. It's unworkable. So the net result was Oliver and Sheffield couldn't stand, of course. So there I was nervously trying to suggest to Lord Briggs that he ought to overturn his own decision, a relatively unusual step. And here we have at paragraph 30, his expression of embarrassment that the analysis couldn't be reconciled with his earlier decision. But as I say, in his defense, I don't think it was really properly argued. So then we come to the conclusion. I've come to the conclusion that to allow subsection 6 to enlarge in that way the nature and type of questions for the FTT on section 27A1 and 3 is to put the anti-avoidance cart before the jurisdictional horse. In my judgment, it was not the purpose or effect of section 27A6 to deprive that form of managerial decision-making by landlords of its ordinary contractual effect, save only to the extent that the contractual provision seeks to make the decision of the landlord or other specified person final and binding, so as to oust the jurisdiction of the FTT. I therefore consider that Oliver and the other two cases were wrongly decided. And this is the key point. We must focus on the meaning of the contract and review the landlord's exercise of any discretion. So the original question, whether there should be a reapportionment, and if so, in what fractions, was not a question for the FTT within the meaning of section 27A6. The question was whether the reapportionment had been reasonable. Again, pausing there, not section 19 reasonable because that's what the contract requires, and that the FTT was able to and did answer the ruling on the tenant's application in section 27A6. So where does that leave us? Well, if you have an apportionment challenge, the question is, what does the lease say? Has the landlord followed what the lease says? And if they have, that's the end of it. So it's a discretion by the landlord that's being reviewed. So it's a Braganza type review, a rationality review, and no more. I'll hand over now to Camilla to try and tie some links between those two cases.
Thank you, Simon. Good afternoon, everybody. Yes, the topic of my talk is to really look at both of these decisions and to try and consider whether there's any themes, and also to look at the practical considerations that arise out of them. Just the first point I've been asked to address was, well, what are the similarities or themes of these cases? But actually, when you stand back from it, they look like very different cases. In fact, you know, in a sense, Sara and Hossein versus Blacks was a case about contractual interpretation. Aviva and Williams was a case about statutory interpretation. So the point in Sara and Blacks was as to the meaning and effect of a contractual provision, which, as David had says, provided for a landlord certification to be final and binding as to the amount of the service charge payable by the tenant, save in cases of fraud or manifest error. And the question for the court was, as a matter of contractual interpretation, did the parties really mean that? And if not, what did the provision actually mean? Did it give the landlord carte blanche to be judge in its own cause unless it acted fraudulently or made a manifest error? Or could the tenant simply refuse to pay on the basis that it challenged the inclusion or amounts of the various underlying costs on a basis that had at least a reasonable prospect of success that would otherwise survive a summary judgment application? Or did it in fact mean something else entirely? So that was what Sara and Blacks is all about. And of course, the focus is on the intention of the parties to a commercial lease, and it's looking at the language that they have used against the context of their commercial interests. And of course, that was quite a short-term lease, and the issue in question was as to the certification of costs. Aviva and Williams, on the other hand, is a case about statutory interpretation, and in particular as to the reach of the anti-avoidance provision in section 27A subsection 6 that Simon has taken you to. And the question there then was, well, what was it the intention of Parliament in enacting that provision to entirely take away from the landlord its contractual discretion to vary a fixed service charge? And if so, did that mean effectively that the fixed service charge would stand in stone for the entire length of the lease, regardless of the inconvenience of that decision, not only for the landlord, but also for the tenant and possibly other tenants as well? Or did it mean that any party to the lease could apply to the first tier tribunal to ask that tribunal to effectively decide whether there should be any change in service charge apportionment, and if so, what the altered proportions should be? And again, if one looks at the table there, one can see that what one's looking at there is not just about what parties to a particular contract meant, but involves much wider policy considerations that are likely to affect the market as a whole. So what, if any, are the common themes? Well, I mean, it doesn't really help to say they're both cases decided this year, they're both service charge cases, and they're both decided by the Supreme Court. None of that probably explains the theme of our seminar tonight, but not a lot else. But I think at the heart of it, there is a single theme or a similarity between the cases, because they're both at their heart. They both concern actually the vexed question of the extent to which the courts or tribunals should exercise control over the landlord's contractual discretions granted by the lease in the context of the certification of service charges and the amount to be paid. And if one stands back and looks at it like that, I think one can see in both cases that essentially what the Supreme Court has done in each is to adopt a very pragmatic response to the issues in dispute, and has essentially adopted the middle ground. And in each case, the reason it's done that is essentially to avoid the undesirable outcomes of alternative analysis, whether that's as to the meaning of the statute or the meaning of the contract. So, for example, in Sara and Hossein and Blacks, the Supreme Court is there finding a middle way under which the tenant is liable to pay up, but also given the opportunity to thereafter challenge the liability to pay the service charge by a counterclaim. And this was said to be fair to both landlord and tenant, essentially, because it preserved the need for the landlords to have control its cash flow in circumstances where the landlord would almost certainly have already incurred this expense, whilst at the same time preventing it from being judged in its own cause. However, I mean, I do think that there is much force in the dissent of Lord Briggs. Effectively, what he's saying there is that the Supreme Court majority is not simply upholding a bargain made by parties, but rather is essentially rewriting it in order to achieve a pragmatic, just response, basically a carve-up between the parties' positions. And similarly in Aviva and Williams, again, I think that what's happening here is that Supreme Court has adopted the middle ground insofar as it's not, in essence, by not construing section 27A subsection 6 so broadly as to entirely deprive the landlord of its contractual discretion, whilst at the same time respecting its function as an anti-avoidance provision, the whole point of which is to effectively prevent a landlord acting as judge in his own cause by ousting the jurisdiction of the FTT to scrutinise the landlord's charges. And of course, again, this would avoid undesirable outcomes, because it would mean that the service charge wasn't unnecessarily fixed in stone for the whole duration of what could be a long lease. And likewise, it would mean that the FTT wouldn't be flooded with requests to make effectively day-to-day management decisions that, quite frankly, it's not designed to and not really fit to deal with. And again, I think that we can see in Aviva and Williams the court upholding the ultimate contractual bargain in the lease as overlaid by statutory protection. And another important Court of Appeal case in relation to service charge is the case of Waller and London Borough of Hounslow, which I'll come on to. But that is the case which applies Braganza in the context of these tricky service charge decisions that the landlord has to make. And Braganza is all about drawing a balance between, the ability of the landlord to exercise its contractual discretion, whilst at the same time preventing such provisions being used as being abused essentially at the expense of tenants. And what the Braganza requirement does, as Simon has alluded to, is to basically impose as a minimum threshold or requirement a test of rationality. I mean, it's quite important to appreciate that this is a different and lesser standard than an objective reasonableness test, but nonetheless, it does impose a minimum standard. And what that standard is essentially a requirement of good faith, a requirement that there should be some logical connection between the evidence and the ostensible reason given for a decision, and an absence of arbitrariness, capriciousness, or of reasoning so outrageous in its defiance of logic as to be perverse. So moving on now to looking at some practical considerations out of each of these decisions, looking first at Sara and Hossein versus Blacks. I think my choice of a unicorn probably tells you something about what my views are on the merits of the Supreme Court's decision. But as David has already said, Sara is a significant case in the context of contractual interpretation more broadly, quite outside the service charge context, because it does seem to indicate a shift again back towards a contextual interpretation approach and away from a literal interpretation. All of the interpretation cases all start by saying that the principles are well established. But the difficulty is in all of these cases, of course, is in applying them to the facts of any given case. And that is usually far from straightforward. I think the reality is that the pendulum is always going to keep swinging back and forth between these two extremes. Most cases will probably be decided somewhere in the middle. But it does mean for us as litigators and advisors that it's actually very difficult and increasingly difficult. And it was perhaps always been very difficult to predict how courts are going to interpret contracts. And of course, that uncertainty is only going to result in more litigation being brought as to what contracts mean. Looking a bit more specifically at about service charge disputes, what is the importance of Sara and Hossein versus Blacks in that context? You know, I think it's inevitable that the decision is going to be waved around in pretty much all commercial service charge cases, and probably some residential ones as well. And it will be said that the case has set some sort of precedent that all clauses or these sort of certification provisions, which are quite common in commercial leases, are basically to be construed as pay now, argue later provisions. But of course, although it's the Supreme Court authority, it's actually only authority for the proposition of what that particular lease meant. If one's trying to sort of step away or remove oneself from the Sara decision, you will obviously be making that argument. Although I think it's also naive to expect to think that parties won't seek to pin their arguments on it. So I think what will happen over at least the next couple of years is that we'll see cases where parties are trying to apply Sara, and there'll be questions about, well, is it applicable? And in particular, might perhaps rather tediously involve us going through and comparing the particular provisions of Sara compared with the lease that we're arguing about, and saying, well, should essentially Sara be confined to its own wording and own decision? Looking at the question of sort of for transactional lawyers and should there be any difference in drafting approach, I think really the key point in relation to that is that you know, if you're a landlord and you intend to extract a basically final certification provision that is determinative of liability and isn't just a pay now, argue later clause, then you're probably going to need to say that, well, even more expressly in your future leases, even perhaps just to say, for the avoidance of doubt, this is a final determinative clause and not a pay now, argue later provision. Of course, if you put it that bluntly in negotiations, the tenant might turn around and say, well, hang on a minute, I don't like the sound of that. And then one will get, the parties would presumably sort of try to find some middle way themselves, which probably will be a better middle way than the Supreme Court imposed on the parties in Sara and Blacks, because, for example, even if it was a pay now, argue later, there could be express provisions that the tenant had to mount its challenge within a short time. There could be provisions for expert determination of that issue, again, in short order. And if there were to be any monies paid up front, it could be, perhaps they could be held by a stakeholder or dealt with in a way which made clear what the parties' rights were in relation to that money, and particularly how they were to be treated in the event of an insolvency. My rather cryptic reference on my slide to a cow for beans is a bit of a Jack and the Beanstalk reference, is really what I'm sort of looking at in that is this really a satisfactory outcome for anybody? I sort of question whether it is. It seems to me it's a fudge, and fudges are never ideal. But I mean, if you look at it from the perspective of the tenant is basically left with a handful of beans because it's had to pay the cash cow to the landlord in full. And yet, its position is that it doesn't have to pay these, it's not fundamentally liable to pay these sums at all. It's then going to have to be put to the trouble to issue litigation, possibly to try to which will obviously be expensive and costly, to get its monies back. And of course that will all be for naught if essentially the landlord is insolvent, or there are other issues perhaps in enforcing a judgment against the landlord. And even from the landlord's perspective, he has the cash, he's left with the cow, but what can he do with it? I mean, in Sara itself, there was a provision requiring sums to be paid into an account only to be used for the purpose of discharging service charge expenditure. That sort of a provision possibly raises a spectre that the effect of the provision is to create some sort of contractual trust arrangement in relation to funds held to discharge service liability. That if that's right, the landlord's options in relation to funds might be more limited. And likewise, the landlord might face protracted litigation by way of counterclaim, and it will have to include some provision in its accounts and budgets for the possible liability that it might face. And of course, it has uncertainty for at least 6 years, if not 12, and that depends on sort of the limitation period, and I'll come on to that, which is really essentially what is the nature of the right that the tenant has to get its money back in the first place. I mean, it's obvious from the Supreme Court decision that the tenant has a right to pursue a counterclaim, but what is the nature of its cause of action? I think my view, and I think this accords with the views of others that I've spoken to, is that it must surely be a contractual right, an implied contractual right to have the money back at some point, because that's the whole point of the purpose of the pay now, argue later bargain that the Supreme Court have said the lease imposed. The only possible candidate otherwise would be a kind of claim in restitution, but for various reasons that doesn't work. There's no unjust factor, and essentially this is not a restitutionary claim that operates outside contract. It's a contractual right to have your money back in certain circumstances. But then the question is, well, if it's a contractual right, when does the cause of action arise? And that could be important for limitation purposes and or the question of interest. Is it the moment when the tenant is liable to pay, when the tenant actually pays, or when the court determines the counterclaim? I don't think it can be the third option sensibly, because if that's right, there's effectively no limitation period in relation to claims to recover money. And if one thinks about it, I mean, a question might arise about, well, is the tenant required to pay under protest? which what you would advise a client who's basically wanting to kind of shore up a possible argument for restitution of monies back. I don't think so, because the tenant has to pay. It doesn't really make any difference if it says, well, I'm not very happy about paying you. If it's liable to pay, it's liable to pay. That, of course, means that the landlord might be blissfully unaware of the fact that it could have a claim form landing on its mat many years later for repayment of service charges that it thought were uncontentious and were settled years before. And again, what happens regarding interest if the tenant has paid interest, because if it paid its pay-up payment late and had to pay contractual interest on it, presumably one might expect that it would be entitled to repayment back of that as well. And likewise, if it does pay up, would it be entitled to statutory interest from the date it makes the payment in relation to any overpayment? Again, as a matter of principle, that would seem fair, because the tenant has in reality been kept out of its own money in that situation. And I think just finally, the other point to notice about Sara and Hossein is the sort of the relevance of the ogre, as I say, of insolvency, because it really seems to me that that was a key factor in Blacks. Blacks had been in administration before, and this lease was entered into against a pretty dire market for retailers. With, we all know that a number of retailers were entering into administration, CVAs, and ultimately going under. So it's hardly surprising that the landlord would want to protect itself by having the money up sooner rather than later. No point having a claim against a tenant once it's gone into some sort of insolvency process. And I suppose the question then is, well, would it be a very different case if in fact the tenant was a very strong undertaking and the landlord was rather more dubious operation? But of course, then the issue is for the tenant. It's paid up its money. Is it ever going to see it back? Just moving on to some practical considerations about Aviva and Williams. I think Simon's covered quite a lot of these, but I think, again, my wise owl here, it's a wise, sage decision. The reality is that it now means that landlords and their agents can get on with their day job and don't have to sort of worry about any of this anymore. But a question arises about, well, how will the FTT undertake a review of the exercise of a contractual discretion in future? And I think I would recommend going back to the Court of Appeal in Waller and London Borough of Hounslow, because Lord Justice Lewison sets out there quite helpfully how it all works and how the sort of tests of rationality and reasonableness would interact. But I think the reality is, as Simon says, is that the FTT will look to the contractual provisions and it will want to be satisfied that the landlord has acted within the four corners of that contract. So, for example, in Aviva, the apportionment had to be undertaken reasonably. So, of course, the FTT would, as it's part of its bread and butter, have to consider questions of reasonableness, but there's nothing particularly surprising about that. And again, I echo Simon's point that although the FTT will always look at whether there's a statutory restriction overlaid on top of a contractual framework, Section 19 reasonableness does not apply to apportionment decisions. So there's no sort of, it's not the case that in every situation the FTT is going to be looking at whether the apportionment was reasonable. And there's several authorities to that, including the Deputy President in Windermere Marina Village, where I think on that point, I think that the authority is still good. He expressly says that Section 19 reasonableness is not relevant to apportionment decisions. And if there is no contractual criteria at all, then of course I think the FTT is going to have to fall back on Braganza and to ask itself whether the landlord has acted irrationally or not. And as Simon says, it's quite clear that the Aviva case settles the point. So if the landlord's apportionment is rational and is reasonable and fair where that's required, the FTT can't impose a different solution simply because it considers another solution or another apportionment to be fairer or more reasonable. That is not within the power of the FTT. I think what's less clear is what the FTT should do if it finds that the landlord's apportionment was not undertaken in accordance with the contractual provisions. My own view on that is that the apportionment revision would be ineffective. So essentially in the Aviva case, that would have meant that one fell back on the old percentages that were in the lease. There would have been no change of that. But I think it could be, if the clause had said that the service charge was to be such proportion as the landlord determined to be fair and reasonable, and the FTT decided effectively that the landlord's apportionment was unfair or unreasonable, I think that the logical outcome would be that no service charge would be due at all. And therefore the landlord would have to go back to base and issue another demand and reconsider its apportionment. And of course, then there could be very interesting, difficult questions as to the timing, because the landlord might actually be out of time for making a valid service charge demand if in relation to costs incurred more than 18 months before. So, I mean, what I think in practice might happen is that I think the FTT will be invited to by parties and possibly inclined in such cases to impose the percentage it thinks is reasonable or fair in that situation. My own view is that if it were to do that, it would be falling into the trap of taking on the role of exercising a landlord's discretion rather than adjudicating upon it. But one can so easily see how the FTT could kind of want to go down that route. And just finally, I think that there could be interesting questions about, well, when does a contractual discretion cross the line of usurping the FTT's function? I think that the guidance on that is quite clearly set out in Aviva. Just clauses that provide for the landlord's determination to be binding and conclusive are obviously rendered void by the legislation, as the same final determinations by surveyors and other third parties that are expressly provided to be final and determinative, again, are rendered void. And further, other types of provisions which might have clauses which say things like, one that's quite common is to say that provided the landlord obtains two estimates and goes for the cheaper one, it will be deemed to have acted reasonably. Well, that's probably, in my view, void under the statute as well, because it's basically saying that the question of reasonableness should be determined in a particular manner. And I think perhaps just to end on a point about, well, what in terms of, well, what is an unacceptable jurisdictional ouster in the context of the legislation? When will where will the line be struck through the wording of the lease? I mean, it's quite interesting to think about if one had the clause similar to in Sara and Hossein and Blacks was in a residential lease. In other words, if there was a pay now, argue later clause, is that a jurisdictional ouster or not? I mean, on the face of it, it would have wording which would purport to exclude the jurisdiction of the FTT, and it might well be struck down on that basis. But if the Supreme Court are right and it's simply a pay now, argue later, one might say, well, it's not an ouster of jurisdiction at all, because the tenant could pay and then still apply to the FTT for a determination as to the payability of those charges as a sort of a first step before then seeking a repayment order through the county court. One difficulty that would be faced in that case is that it's still a service charge, whether it's payable as a sort of interim pay now, argue later kind of payment. So it would still be subject to a reasonableness requirement under Section 19. So I don't think in reality the landlord's going to get very far in that sort of a situation seeking summary judgment against a residential tenant. as it will face, almost certainly face an argument that the charges aren't reasonable and therefore ought to be determined by the FTT rather than the court. And just my last point is about resolving apportionment disputes in commercial leases. I think my point here is more generally the apportionment disputes can be highly contentious in commercial service charge disputes between parties. You might well find in a commercial lease the sort of expert determination clause that was in the Sara case, and one gets quite complicated issues about apportionment across, say, for example, in a shopping centre, one might expect to have weighted provisions or for a scheduled approach to be adopted so that certain tenants didn't have to contribute to certain costs because they didn't benefit from them, and that can be extremely contentious. But I do think that the commercial world is a slightly different animal here, and really the main trend in commercial service charge at the moment that I've seen is that essentially the market is overtaking events, because the reality is that with rates what they are and the market as it is, most occupiers now are resisting having a service charge, or more probably in most cases trying to impose a service charge cap. And some of the disputes are now moving into the kind of lease renewal sphere about whether service charge caps should be put into lease renewals. So it is very much more dictated by the market, and there's less expectation, I think, from a commercial landlord that it's going to be able to basically have 100% recovery. So thank you for all listening to my sort of fairy story. And I think we've got time for some questions. David.
Thank you, Camilla. I'm not sure we have actually. We've run. It's now 6:30, and we've run slightly over time. There was one typed question which about the practical problems which the pay now, argue later might arise. But I think you've dealt with that, Camilla. I think you answered there may be a problem in that. There may be a problem if, for example, the landlord goes bankrupt, or it's difficult, is out of jurisdiction, or it's difficult. So, in the absence of that, and looking at the time, I think we'll draw this session to a close. Thank you all for listening. If you've got any feedback, we'd like to hear it. If you have any burning questions, which is something I think of no doubt you can get in contact with each of us via Chambers. And thank you very much to everybody, and a good night.